will actually do? It's a good question. I've been asked it several times. What does a will actually do? Many people know they should have a will, but they are not always sure what a will actually does. So today we're going to talk about that. A will is a legal document that allows you to provide instructions on how your estate should be handled after you pass away. In other words, when you die, you're going to instruct what happens to your estate, meaning those things that belong to you when you pass away. In Utah, the legal requirements for creating a valid will are outlined in Utah Code Section 75-2-502. A properly executed will generally must be in writing, signed by the testator, and witnessed by at least two individuals. And there's some words in there that you need to understand. A testator. The testator is the one who's making the testament or the last will and testament. So the testator is the one who signed, and if you're making the will, the testator is you. And a witness is someone who witnesses the testator sign. So two individuals who are independent witnesses. A will serves several important functions. First, it allows you to name the beneficiaries who you want to receive your property. Without a will, the distribution of property is determined by what's called Utah's intestate succession laws. And those are found under Utah Code, Title 75, Chapter 2. Intestate succession means you died without a will. That's what intestacy or intestate means. Second, a will allows you to appoint a personal representative. In other states and in times past, that person has been called a executor or an executrix of a will. In Utah, we call them personal representatives. And this is the person who's responsible for administering your estate, making sure everything's taken care of, representing your estate. So a personal representative's duties include gathering assets, paying debts, distributing property to the beneficiaries. Third, a will allows parents to nominate guardians of minor children. So if you die and you have minor children, children who are under the age of 18 that need a guardian to take care of them, a will can nominate people to be appointed to that position. If parents pass away without naming a guardian, then the court must make that decision without your input. A will allows parents to express their wishes ahead of time. However, it's important to understand that what a will does not do. So sometimes people think a will avoids probate. That is simply not true. A will does not avoid probate. Assets governed by a will generally must go through probate, described in Title 75, Chapter 3 of the Utah Code. This is why many estate plans include additional tools such as a revocable living trust. If you have a trust that is properly funded while you are alive, and there are no assets that need to be distributed by a will or outside of probate, then you don't need to go through the probate process at all. So trusts typically eliminate probate, but a will does not eliminate probate. A will is an essential part of most estate plans, but is often only one piece of a larger strategy. If you would like help creating a will that protects your family, aligns with your goals, you can call me. I'm attorney Jeremy Eveland, 801-613-1472. You can also click on the link in the description below, complete a short application to see if we would be a good fit to work together. I hope you found this helpful. Thanks for watching.